Everybody say, ah. Say, oh, oh. Say, how can I express my gratitude for all the many things you've done for me? Words are not enough, enough to say thank you. Say, Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things, you've Father, you done for me, yeah. Words are not enough to say thank you. So Lord, you are, you're my everything. Say, I call you God.
And we made it. We are into 2025, the first Saturday of the year, the first Saturday of the month of January, and we are live. The community and the law has come your way again. I'm going to ask you this very question, and I know by courtesy of BWF solicitors, we're going to have an answer. Can an overstayer apply for leave to remain in the UK? If you're ready, let's go into it and get the answers together. My name is Oreku Frimpong, and this is the community and the law.
Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345, or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpong, and I am your host.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
And we are live. Good afternoon to you. It's a very cold Saturday afternoon here in the UK, but we have warmth in our hearts, and coming from BWF Solicitors, we're bringing you the community and the law. My name is Oreku Frimpon, and I want to say Happy New Year to you. Welcome to 2025. We made it through 2024, and we're glad that we're going through to have a wonderful year 2025. And the community and the law will be coming your way every Saturday afternoon, as we do between 4 and 6 p.m. UK time. And we're doing this courtesy of our trusted partners when it comes to the law. We're talking BWF Solicitors. They're located on the 4th floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters in North London. You can call them Monday to Friday between 9:30 in the morning and 6 p.m. in the evening on 0208 493 7340. They have an office in Ghana, and you can reach them in Ghana on 055 589 5959. 055 589 5959. Or in emergency situations, call, text, or send a WhatsApp to 004477 127 61884. 004477 127 61884. Now, a wise man once said, Martin Luther King, and I want to quote, he says that you don't have to see the whole staircase, just take the first step. So, what we're doing this afternoon is taking the first step, and we're moving straight into the year 2025. And we're going to have all our legal issues, all our legal questions on all of them addressed by the competent BWF solicitors. And this afternoon, we're so lucky and fortunate to have one of the astute lawyers from BWF solicitors with us to help us unravel the situation we have on hand. And the question I'm asking is, can an overstayer apply for leave to remain in the UK? Lawyer Charles Asma is our resource person and guest from BWF solicitors. And before I do anything, let me just welcome him and say Happy New Year to you, Lawyer Charles.
Happy New Year to you, Brakoku. How are you?
I'm doing very well. I keep saying that we are lucky. Yes, we've made it into a new year, and we're so grateful to God, and thankful to you as well for giving us the opportunity to empower the community as we do normally.
Yes, I agree with you. I suppose grace found us, less of our luck. And so, yes, here we are, 2025. We are expecting wonderful and better things. And the lessons learned in 2024 will be our benchmark and guide. So we expect that with the knowledge, skills, experience, the community will benefit, and together we'll make everybody happy.
Well, definitely, we together will make everybody happy. And viewers, listeners, and our clients, we would want to say thank you to BWF solicitors for being there for us. And one of such wonderful people has written something so nice about BWF solicitors, an experience had in the year 2024 going into 2025. And we have Mercedes Inshira. Mercedes Inshira is giving us some review. And BWF solicitors, let's get into it and let you know what Mercedes Inshira is saying. She says, after a refusal of my two children's applications from the Home Office, I went to Uncle Ben's office, BWF solicitors. I presented my case to Uncle Ben, and he gave me a listening ear. He took his time to explain and gave my case to Lawyer Charles, who was also a fantastic person. I call him anytime and he picks my calls. Even the day I was going to court, he prayed with me on the phone. And to God be the glory, my two children have joined me here in the UK and have been with me for 6 months now. Well, Uncle Charles, I think your name is directly mentioned here. So I want to say Mercedes is grateful, and for a client to write such a very nice thing about your organization means that you're doing a very wonderful job for them. Thank you very much, and keep doing what you're doing, Uncle Charles.
Thank you. Thank you. Yeah, well, there are so many clients. Mercedes, the name doesn't ring a bell, but I suppose, yeah. Thank you so much for the review. And this is what we do as community lawyers. We want to make sure that whatever knowledge, skill, talent we have, we put to the use and benefit of the community. And it's a testimony that when you knock on our doors, we'll do whatever possible, work with you, and ensure that we use the law to assist you, the family, and everybody through whom we have to act for. So thank you, Mercedes, and all the many people who continue to give us testimonies for the benefit they are getting from our work. So thank you.
Well, I have an interesting question. Let me put it this way. Is there any case that is so desperate that you can't handle?
Well, there is something called balance of probabilities.
Okay.
So when you assess the case, there's always a balance. There's never
Mhm.
100%. I tell people that even if yours is 1%, 20%, or 90%, it means there is a chance for you. Because if yours is 1%, then you have
Mhm.
to know how to use that, maximize that chance you have. And so the most important thing is the expectation. I tell clients that, yes, this is it. We have to work with it. The law is there. We apply the law to ensure that the people get what they need. And so to answer the question that really, I don't think there is any case that is insurmountable. If
Mm.
the law allows it, then we make it work and we let the client maximize a chance within that case scenario.
Okay. Well, just present your case to BWF solicitors. So very particular as to what they need to do, and as Lawyer Charles said, they weigh the probabilities and they see where it is. Even if it's a 1% chance, they will give it a shot. And many people, like Mercedes Insura, have had the benefit and have had success with them. Call them on 0208 493 7340 or 077-127-61884. Oftentimes, you can also call Charles, as Mercedes said. Anytime Charles is called, he picks up his phone. So let me give you his number and give him a call, and then you also benefit from the service that he provides. So let's put in Charles's number on the screen for people to write down, but I'm going to read it out. Charles Asma is on, let me get it to you right now, 07947 That's the number of Lawyer Charles Asma. You can call him direct or go through the main line of BWF Solicitor 0208-493-7340. Those of you who have come on, yes, I often ask you to do the needful for me. announce yourself, share the link, like the page, and also let's see and feel you in the comment section below. Sandra Fraser, you've done that. Thank you very much. Bernard Tete, we appreciate you. Thanks for coming on board. And of course, there are a lot of you that are still to make your presence felt in the comment section. I'm waiting for you, and we'll do that. Now, let's look at a piece of information that BWF Solicitors put out at the beginning of the week. Leave obtained by deception does not count as continuous lawful residence. What we're talking about. We know that when you are here in the UK as not a British national and you come from any other country, your leave to remain has to be lawful. And we have also been made to understand that at a point in time, you can count the number of days and the period you've left here. So you go to have the indefinite leave to remain and move on to naturalize and then become a British citizen. But the continuous lawful residence, what are we talking about? And how do we calculate that? There's this case, R versus Secretary of State for the Home Department 2024 case. Says that, or from the case, I should say, leave to remain relied upon to satisfy the requirement for 10 years lawful residence must have been lawful. That is, not obtained by deception or otherwise in breach of immigration laws. The court has found that lawful residence must exclude leave obtained by deception and therefore unlawfully. So, how do you obtain that? Which one is lawful, which is unlawful? And that count towards continuous residence. How do we do that? I believe we have lawyer Charles Asma here, and I don't have to go through and struggle to do that because the legal person is here. So, my learned friend, what are we talking about?
Thank you very much. Viewers and listeners, once again, Happy New Year. We are through and we are here. Yes, we know that if you have been legally resident in the UK for 10 continuous years, and the word is continuous, that means no break, you qualify for indefinite leave to remain. That's a starting point. Very soon, because this is a very technical area and itself is a topic, we'll spend a bit of time. But producer will share the guidance with us so that people will have their perspective. So you have done 10 years within the rules. You qualify for indefinite. What if, and let's look at the exceptions. So where it says that if you, within that 10 years, if you're in prison, you are not part of it. If so, producer, thank you so much. So if you take us back to the nugget, please, whilst then we'll come back to this one. Right. So it says within that 10 imprisonment is not part of it. That is if you are in prison for criminal offenses. That is not part. The reason is that if you are in prison, liberties are taken away, and so you cannot enjoy life per se. So if you are in for 1 year, 2 years, that is taken from the continuous residence.
Okay.
What if, you see, the law did not make mention of how that so-called legal residence is obtained. Is it legal residence? What if that legal residence, lawful residence, right? So you may have 2.5, that's lawful. You may have student visa, that's lawful. Skilled worker, that's lawful. Whatever it is, it's lawful because you've gotten it. But the law also says that if after giving you that lawful residence, it is found out that you used deception to acquire it, then it is no longer in a way lawful. I don't know if you get the analysis. So if you use deception to get it, can you benefit from that deception?
Well, that obviously, if you are going to do the right thing, obviously you're not. Yes.
The law says no. And so, if you cannot benefit from that deception, then if you are counting the lawful residence, you cannot count the one that you obtained out of deception. And that is the case law now. Before, it's all okay. But the case law 2024 now says that, hang on, if at any point in time the Secretary of State finds out that you use
Mhm.
deception to obtain one of the leave, that counts
Okay.
toward the 10 years. You
Mhm.
cannot take advantage of that.
Okay. Now,
So now,
I know you may want to go through that, but let me ask the question here: that how do we determine that something is deception?
right. So the law says that if you use false representation or false documentation to obtain leave,
Okay.
then the leave is deemed to have been taken or obtained out of deception, especially if the person knew that the information or the document was false. And if
Okay.
it is false, and you knew that it was false and you used it, then there's deception.
Okay.
Because if not for that, that leave maybe would not have been granted.
Okay.
And because of the fact that they didn't know, they relied on your information and they gave it to you. And later they find out that, this one, if we knew, we wouldn't have. And we probed and realized that the person knew about it. Then that's deception. Because there's intention to obtain that information, the visa, using whatever information you presented. But it is again up to the Secretary of State to prove that, yes, there was deception involved. So, in the case that we are looking at, the case of R, the Secretary of State, it simply says that if you use deception to obtain leave, then you cannot benefit from that leave as to count 10 years. So that when you think you are now 10 years, so you are going for indefinite leave to remain, that is where the process will be halted and you will be questioned that, hang on, at a point in time, one of the leave or a particular leave was not obtained lawfully, and so it cannot be lawful residence. It's a technical argument, but it is what it is because the case has gone through the process and upper tribunal has decided that this is the position. So the court has found out that lawful residence must exclude leave obtained by deception and therefore unlawfully. You see, it says deception, and if it is deception, then it was obtained unlawfully. And
Unlawfully.
if that leave is obtained unlawfully, can that residence be lawful?
No, no, because
Exactly.
you
So
wouldn't have been giving if you said something
exactly. So it's
else.
analogy, and it flows on from one to the other. So what is the learning here? Of course, eh, nobody knows how people obtain their leave, but the case law is clear that if it is found out, then it will be deducted from the 10 years continuous residence. And so when would they find out? That is when you apply for indefinite leave and they pick something up.
Okay. So in that situation, Laura, if they find out that within the 10 years, say after 2 years, they find out that you had that by deception, and they say then you haven't stayed continuously, and the year or so or that gap, what happens? Do you start from where they caught you, or you start straight from the beginning, or is a blatant refusal?
Well, I mean, you can appreciate that this is a fresh case, and this is where the law is tested
Okay.
because it's fresh law. So the question here is, which part of the teeth of this law bites harder?
Okay.
It's saying that if within the 10 years there was unlawful acquisition of residence, it will not count.
Hmm.
What does it mean when the law says it does not count? That's a phrase. What does the phrase mean? And
Hmm.
it's subject to interpretation.
Interpretation.
Does it mean that it will not count because before it will be taken away and you have to start from there? Or it doesn't count in a sense that we will remove it from the total 10 years? My interpretation would be that it does not count means that we will not add it to the 10.
Okay.
And if we are not going to add it to the 10, if it was 2.5 and we are not going to add it to the 10, then you have to make it up.
Okay.
That would
So
be
if
my interpretation. But
if
again,
you were on the 10-year route, and one of the two and a halves that was giving you, they think it was acquired by deception. Then it means that at the time that you think you have reached your 10th year mark, you'd have to spend another 2.5 years. Is that what it could mean?
I like what you have said. Is that what it could mean? It didn't ask me, is that what it means?
Hmm.
It could mean that, depending on who is interpreting it,
Okay.
you interpret it in a way that favors your point. So if I'm interpreting it, I'll interpret it to mean that the law says it doesn't count. That means if I have counted 10, I have to remove that one from it and make up for the difference.
Hmm.
That means I have to wait extra. I have to wait to make up. If it is 2.5 years or 3 years, I have to wait to do those periods.
Hmm.
Somebody will also interpret. So you can see that this interpretation is a favorable interpretation, isn't it?
Well,
But
depending on how you understand it.
exactly, but the Secretary of State will not interpret it favorably like this. The Secretary of State will say that, hang on, not counting means that you shouldn't have had it in the first place. And so if we take it out, where the gap is, you have to start it from there.
Okay.
And that will be hostile interpretation. And so it's a battle of the law. The argument will then determine whether it will. So, and that is why somebody can also go further to say, in this case, can even go to the next step
Hmm.
for example, a court of appeal to make an interpretation of what it means by does not count. But as far as my understanding is and my interpretation of this ruling is, I would say that it doesn't count means that, just like the case of Abza and Yeki, which says that if there was a break in the 10 years continuous residence, you have to make up for it.
Hmm.
In the same, so we can see that we can compare the two cases and say that this is similar to the case of Abza and Yeki, where if, for example, there was a break and you didn't, or you became an overstayer at a point because your visa expired before you applied for a new one and so on and so forth, and you think you are now 10 years, you are going for indefinite, they will tell you to make up for the difference. The same way, this one is not about there was overstaying bit, but it says you acquired it unlawfully. Acquiring it unlawfully and we removing it means that at that point you became an overstayer, isn't it?
Hmm.
And so the conclusion is that for us, members of the community or public, we have to understand that the law has now turned, and Secretary of State is now taking steps to even recall people, the leave granted to people, scrutinize to see whether any of those 10 years leave granted was obtained unlawfully. If it is taken that it was obtained unlawfully, case law says that it should not count toward indefinite leave residence. That means you are not there yet. But the question is, should I apply for another limited leave to remain so that I can do up to the total 10 years if this doesn't count? Or I have to start all over again? That is what we are going to do in terms of testing this law.
But I would want to be daring and say that if it applied to me, I would push that my legal reps, possibly BWF solicitors, would test the law for me and see where it is. So the nugget this week on the case law R versus Secretary of State for the Home Department 2024, UK Upper Tribunal Law or Case 00417, and it says that lawful residents must exclude leave obtained by deception and therefore unlawfully. So, on that, let me ask you this question. I'll give you a scenario. Let's see what answers you probably would be able to put across. Kofi Azar was granted indefinite leave to remain under the false name when he used a different name. That leave was subsequently revoked on the grounds of deception for using the false identity. He was subsequently granted leave to remain on the basis of his family life as he has a British citizen child. He applied for indefinite leave to remain, combining his previous leave obtained by deception with his current leave. His application was refused. The Home Office cited the use of a false name and the revocation as reasons he cannot rely on the previous leave. So the question is, will he succeed if he appeals? Three answers. One says yes, because he had already had lawful residence before it was revoked. No, because his name was different. And the third one says no, because the previous leave was obtained by deception. Therefore, the leave is unlawful. Think about this. I'll come back to you with this one at the tail end of the program, where we had the discussion and finished with it and taking your questions and concerns, and we'll be back. We're here courtesy BWF Solicitors. Let's take a break, and when we come back, we'll look at our question and the topic for today. Yeah, lawyer.
Yes. So, if quickly, producer can just point us to page 24 on the guidance, just so
Okay.
look at how the break comes about. Page 24, please. Page 24. Scroll down, page 24. Oh, okay. Are we there? Okay. So up, please. Okay. All right. So breaking continual residence. Brad could take us through just the key reasons. One, what's the first
Okay,
one?
the one says absences from the UK.
All
And
right.
it continues to say continuous residence is broken in specified circumstances, such as when an applicant is absent for more than 180 days in any 12-month period without permitted reasons.
So that's one. So within 10 years, if you've been absent from the UK for 6 months, we always say 6 months within 1 year, then your continuous residence is broken. So that's one. Two.
Is applying under appendix long residence and was absent for a period of more than 6 months. That is 184 days.
No. Let's just jump to the next heading.
Okay. So
okay, again, the next one. This is
the
just
next one,
explaining
yes,
the first one.
that explains the previous one. Yeah,
the next
imprisonment
is the
and detention. That's one of the reasons.
Yes.
And an applicant's period of continuous residence will be broken if they are convicted of an offence in the UK and sentenced to a period of imprisonment. This does not include suspended sentences, which do not break continuous residence.
Right. So, so we know imprisonment also count towards break. What else?
Yeah.
If you scroll down.
What else? Deportation and exclusions.
Okay, so
this
these
is where
are
an applicant's period of continuous residence is broken if they are subject to any of the following: a deportation order, exclusion order, and exclusion direction.
Yes, and if we go down, yes, another one.
So removal direction. And this one says an applicant's period of continuous residence is broken if they are subject to removal directions or for applications under appendix long residence. They are removed from the UK under Section 10 of the Immigration and Asylum Act of 1999. Time spent in the UK before the removal direction was made and while the removal direction was extant does not count towards continuous residence unless they are being considered as part of an application under appendix long residence.
Right. Yeah. So these are all reasons. The next one is overstaying exceptions as well. So these are exceptions to overstaying. We are not going to go into it. At least the aim is for people to understand what counts toward break. So you can see that none of this mentioned if you obtained your visa unlawfully within the 10 years. And this is the first time in the period that we are hearing about this in 2024 in this case law. And that is now one of the factors or reasons why you will not have a full residence, but you have a break. And unfortunately, we'll deal with it as and when cases come about.
Well, so and then basically upon that, we can take our break now. When we come back, we're looking at, can an overstay apply for leave to remain in the UK? Who is an overstayer? Leave to remain in the UK and all the things about it next.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
And we are back, and thank you for sticking around with us live on BW TV. We're bringing you the community and the law. We're doing this by courtesy of BWF Solicitors, our trusted partners when it comes to the law. Can an overstay apply for leave to remain in the UK? That's our topic for today. And our resource person and guest this afternoon is Lawyer Charles Asma. Lawyer Charles, it looks like a straightforward question. Let me ask again. Can an overstayer apply for leave to remain in the UK?
Yes, if the overstayer meets the requirement of the particular category of the leave that he or she intends to apply under.
Okay, so then let's unpick them, the conditions. Let's start with this. Who is an overstayer? And then we can build on from there, lawyer.
An overstayer is somebody who has lived in the UK beyond the limit of their stay or their leave. So if you are granted 6 months, for example, you become an overstayer after the period. If it's 6 months, end of the 6 months. However, there is another angle to those visitors, because if you apply to enter the UK as a visitor, you say that I'm entering for 2 weeks or 1 month or 6 weeks, whatever. Even though you are granted 6 months, they don't expect you to live in the UK for 6 months. So they will always ask you, how long do you intend to be in the UK for? So if you tell them that I intend to be in the UK for 10 days, and you live in the UK or stay in the UK for more than 10 days, even if your visa is not expired, you are an overstayer. So those are the semantics.
Does it mean that, for instance, now my visitor's visa, as an example, I was giving 6 months multiple. Now, when I enter, do I have to stay for the period that I stated in my application, or I could stay for 3 months, whatever, within the 6 months?
The question is, what is the rationale of 6 months multiple visa? Is it to stay for 6 months or to go and come so that you don't have to apply again within 6 months? What's the rationale?
Well, for instance, I decided to come and attend a graduation ceremony, for instance.
No. What I'm saying is, if you are given 6 months multiple,
Yeah,
it is not for you to stay for 6 months, but it's to make it convenient for you so that
for you to be able to come in and out.
having left, you don't have to pay another money and go through the process to apply if you are coming again within the 6 months and you still have a valid reason.
Okay.
And the question here is, what do we refer to in terms of how long you are required to remain in the UK? It is what you have said, isn't it?
Yes.
And what you have said is on the application form.
Okay.
So if on the application form you have said that you intend to remain in the UK for, let's say, 1 month, then you are expected to leave upon 1 month.
Okay.
But you can enter. That is why it's multiple.
Okay.
If there's still reason to enter. So you don't
Okay.
have to say that, yes, I said I'm going to be 10 days and I've been given 6 months. Then let me stay because I think they want me to stay for 6 months. No. They think you want to stay for the period you indicated.
Okay.
So there are two rationales. Your own time, which you have indicated, is
Mm-hmm.
standard. You cannot change it unless you become unwell and you can't travel, or there are special reasons, insurmountable obstacles that prevent your traveling at that time. Then you can have reason why you have overstayed.
Okay.
But so that is one level of overstaying. The second level of overstaying is going beyond the limit of the visa completely.
Okay.
These are the
Um,
two for visitors.
yeah. In a visitor situation, let me also look at this. I've been giving 6 months multiple. The initial entrance, I mentioned that I was going to spend 2 weeks. I've spent the 2 weeks, I've gone back. I have another reason of coming back to the UK within the 6 months that my multiple visa is valid for. Now, the next or the second entrance, where do I state? Or I'll have to tell the immigration officer at the airport that I'm here to spend 10 days, and then they will put that on my record. What happens?
Yes, obviously, if you are returning, they will ask you. It depends on who the officer is. Some officers will check only the visa and let you pass. Others will
Okay.
ask you, "What's your reason this time?"
Yeah.
Then you they will be satisfied. Then they will let you. So it all depends. It's a case by case. Somebody will go through. Somebody will be told, "No, you can't." But there are instances where, for example, the person said they were entering for, let's say, graduation or an event, and this is a specified occasion.
Hmm.
They've attended and left, and they are coming again. Wouldn't they be asked to tell what for this time?
Yeah, obviously, yeah.
Exactly. Yeah. So then there should be a reason. Maybe this time they are visiting a family because there's family emergency and they are needed, so they are rushing in and back. Or there's another event again and they have more time on the visa, the first one, so they are entering but not necessarily applying for another visa. So they have their reason with all the evidence. Because even if you are entering again, so the understanding is that people will have their reason either on paper or in their mind so that they can disclose when they are questioned. But the caseworker has um, power to ask, and it's your duty to explain why you are coming within that 6 months, even though your visa has not expired. So for visitors, if you stay beyond the days you said you'll be spending in the UK, even if you still have visa, is deemed an overstay. Again, if you are given a certain number of years, 6 months, 2 years, or whatever, and you decide to stay till you said to stay, or you've been there and the visa now has expired and you are still in, of course, you are an overstayer. So those are the angles. We also look at students. You enter
Okay.
as a student, you'll be given time to study, complete, and leave. If you've completed, and if you have not left, then you have overstayed. That is again skilled worker. You've been given 2 years, 3 years, or whatever, and there's no opportunity for you, or you have not decided to renew or to move to indefinite. Then, if you have a break in the period for staying in the UK, 2 years, you didn't renew, the visa has expired, then you are an overstayer. Or the visa is cancelled, you are still in, you are an overstayer, whatever. So if there's cancellation and you don't do anything about it, you are an overstayer. The visa has expired, you don't do anything about it, you are an overstayer. Obviously, if you came to settle, then you cannot be an overstayer. But even that, you are given 2.5. If you don't renew it,
Hmm.
you are an overstayer.
Okay.
The only point where you cease to be an overstayer is where you have indefinite leave to remain. There's no immigration control, no restriction. Apart from that, whatever you have is limited. And so you have to always renew it. Otherwise, there is a break and you become an overstayer.
Well, having known these situations where one could fall into the category of being an overstayer, um, I come to the question: if I have overstayed and then I am deemed as illegal, what will make my situation be corrected?
Right. Thank you very much.
It's an interesting bit, isn't it?
Yeah, I mean, yes. I mean, so the question is clear. Can an overstayer apply for leave to remain? And we have
Yeah.
said yes. And please, viewers and listeners, the understanding is this. Being an overstayer and regularizing your stay means you are now taking steps within the rules. And that's why the
Okay.
question says, yes, we agree you are an overstayer, but can you apply? Making an application is the right thing to do, isn't it?
Okay.
And
Yeah.
therefore, can people now make the right thing to remain in the UK legitimately? Answer is yes. What are the options or the parameters?
Hmm.
One, we look at Appendix FM, family migration. What it means is if you're an overstayer,
Hmm.
you can remain in the UK and apply on the basis of a family relationship without necessarily having to leave and apply to come back.
Okay.
That is one. So as
Okay.
a family, we are looking at you are a parent, so you want to apply to remain with your children. If your children qualify to remain here, so you have to be here for them.
Okay.
So that's parent. Or you are a partner, so that you have a partner who qualifies to be in the UK. And so you are applying to remain in the UK with them, even though you are an overstayer.
Okay.
So we have partner, we have parent, and the next thing is child. You are a child. You have overstayed. Your parents are in the UK. They have what it takes to be in the UK. And so you want to apply to remain with your parents. Then you can also make an application, even though you have overstayed, to regularize your stay in the UK. So if you look at three angles within family migration portfolio,
Mm-hmm.
parents, children, partners. Let's open up parent. If you're a parent, that means your child is a qualifying child. That means your child is British, your child has indefinite leave to remain, or your child has pre-settled, either of them, or your child has lived in the UK for 7 years. And
Okay.
these four factors give your child access to remain in the UK. And because your child has these four, or one of these four, your child is a qualifying child. And as a
Okay.
parent of a qualifying child, on the basis of your family life with this child, is it okay for the law to allow you to remain with your child? The law says that if it is okay in the interest of the child, then it is okay for you to remain with the child.
In the Egypt. Okay.
So that is one angle,
Yeah.
being a parent. What about being a child? That is, if your parent has something, again, if your parent has indefinite, or your parent has pre-settled, or your parent has British citizenship, what we call qualifying parent. In this case, you also make an application saying that my parent is the one looking after me. Yes, if I go, my parent will continue. However, the level of care and support will not be as I'm here with my parent. And so give me opportunity to remain with my parent. And the parent will also support with the same level of explanation that my child under my roof is better than my child away from me. And
Hmm.
so it's okay it's better for my child to remain with me. Then argument will be made for the child application to be made. That
Now,
is
let me look at this child-parent relationship and the scenario. We have a child born in the UK to a parent who has 2.5 years. The parent at the end of the 2.5 year period renews. Doesn't automatically renew for the child as well.
Can you please clarify the point for me?
What I mean is, I am here in the UK and I am on a limited leave to remain 2.5 years, maybe for 5 year route, on a 5 year route or whatever. Now, within the 2.5 years, I give birth to a child. What will be the status of a child? If I'm renewing my 2.5 years, does it affect my child as well?
Right. Good point. Of course, these are things that happen, and we use the law. So here, who are we going to fight for? Is it the parent or the child?
Well,
It's the child,
both
isn't
of
it?
them
It's the
maybe.
child. No, it's a child. The child has just been born.
The child has just been
The
born.
child hasn't
Yes.
done anything.
Yeah.
Ideally, if the child parent is British, the child is British anyway, under Section 1 of the Nationality Act. If the child parent has indefinite, the child has indefinite, the child is British as well. But
Mm,
we know that the child parent hasn't gotten indefinite, has limited leave to remain, 2.5 years.
mhm,
So what do we do? The law says that if, for example, the child was away and the mother has 2.5, or the whatever the parent is, that parent can apply for the child to enter to remain with them anyway, because the
mhm.
parent application is the one leading to settlement. So
Okay.
my question is it in the interest of the child for a decision to be made that the mother doesn't have indefinite, so the child should be removed from the UK? The mother cannot be touched, but the mother is still on his, or the father is still on the journey. But what about
Mhm.
the child? And so the argument would be that if the mother cannot be removed, why do you remove the child? And therefore, it's in the paramount interest of the child to be given 2.5 as well, or
Okay.
to be
So,
given the limit left on the mother's stay.
so in this case, the child technically being an overstayer can apply for leave to remain because of family ties.
But why do you say the child is an overstayer? No,
Because
the
at the
child
end of
does
the
not
day,
qualify. The child
whatever,
does not, yeah, the child doesn't fall within the remit of overstay because the child has just been born to a parent who has stay, right?
okay,
Yeah, so the child hasn't been given a visa and the child has
okay,
overstayed the limit of the visa. So the overstay conversation has not been engaged here. The
okay,
question is that having been born to a parent with 2.5, should the child remain as as on the basis of the mother's stay, or the child
mhm,
should remain illegal, so to speak? The
okay,
argument will be that the child should be given the stay left on the mother's stay
oh, okay,
or the
okay.
father's stay, of course.
Okay,
Yeah.
so we technically we can't classify that child as an overstayer, but rather we need to regularize the child's stay here in the UK based on what the mother or the parent has.
Yeah, so the child will be a child without leave to remain, but not necessarily an overstayer.
Okay, all right. Moving on, you mentioned that students who have been given the right to study here in the UK and have finished with their course have not gone back to their country could be overstayers. In their situation, is there any hope for them?
So we are still discussing the overstayers within the law right to apply to remain in the UK. So it is regardless of your status. What we are saying is that if you're a parent, you can regularize your stay. If you're a child, you can regularize your stay. If you're a partner, you can regularize your stay. And therefore, if this student has a partner, they can regularize their stay. If this student has a child, they can regularize their stay. If this student is a child student and their mother or father in the UK with the necessary requirement, they can regularize their stay on that basis. Family migration, Appendix FM. Of course, we have to then define who a parent is, who a partner is, and all that. We are not going to definitional issues, but suffice to say that a parent is somebody who has parental responsibility within the remit of the Children Act of 1989. And therefore, if you are a biological parent, a step parent, or a guardianship or special guardianship, then you have the opportunity to have a parental responsibility towards the child. And if you have a parental responsibility, then you are a parent. Again, if you are an adopted parent, then you're also a parent with parental responsibility. So that is the definitional aspect of parent. In terms of partner, the law says under paragraph 6.2 of the immigration rules that a partner is somebody who is married to the person or who has been in a relationship with a person for 2 years. And even though they are not living together or they are not married, they are behaving as if they are a couple. And that is the definition. And doesn't really matter the sex because that, I mean, for stereotypical and discriminatory angles, we do not say you must be man and man, woman and woman, or this and that. The law says partner. Now, so that is put to bed, and it doesn't really matter your original status or initial status, provided you meet the requirement of the rules, the validity requirement, eligibility requirement, financial requirement, and if some are not met, the exceptional circumstance requirement, then you can apply to remain in the UK. All we are saying is that you must apply, and to apply means you must meet the rules under the particular application you are applying under. So that is that angle. Again, we move on to other aspects. You are an overstayer. So you look at Appendix FM. Now again, you don't qualify to make an application under Appendix FM because you don't have family relationship. You don't have a parent, or you don't have a partner, or you don't have a child. Then no family matter. Then we are looking at private life. So you've been an overstayer. The law says under Appendix private life, there are two aspects, actually three: 4.2, 5.1a, and 5.1b. 4.2 talks about children. If you are a child overstayed and you have spent half of your age in the UK, you can apply on the basis of your private life.
Okay.
So that is 4.2 for children, private life. There's also, and again, that we are looking at children between the age of 18 and 25. So we have to define adult children. So you see, we have children, adult children, and super adult, so to speak. So children under 18, we are not talking about. For children, if you have spent 7 years in the UK, you are under 18, private life. You go for indefinite leave to remain. If you have spent 10 years of your life as a child and born in the UK, you apply for citizenship. But if you are now 18 years, you are not a child. And so you are semi-adult. But you are not 25 years or over 25. So the law says between 18 and 25 years. If you can prove that you have been in the UK as an overstayer and you have stayed in the UK half of your age, then we have to put pen to paper and do the calculation. One, what is half of your age? If you are now 20 years, that means you should have been in the UK for 10 years, right?
10
Which is
years,
half
yeah.
of your age.
Mhm.
If you are now 18 years, then you should have been in the UK for
9
9
years.
years, half of your age. If you have been in the UK for 24 years, then you should have been in the UK for 12 years, continuous, half of your age. Those are the parameters in terms of the mathematics.
Okay.
Then we go to those who are beyond 25 years, so 25 and above. The law says that 25 and above, you are adult automatically. I call it exceptional, I call it pure adult. 18 to 25, I call it semi-adult. So pure adult, 25 and above. Then you should have been in the UK for 20 years continuous to qualify for private life. And that would take us to 5.1a of Appendix FM, Appendix Private Life. A says that 20 years in the UK you can apply, but you must prove it. all of them you have to prove it by way of evidence that you were in the UK. Then B says that if you are less than 20 years, but you have exceptional circumstances that makes your removal from the UK unreasonable, harsh, then you can make a case. We call it insurmountable obstacle.
Okay.
And so those who are less than 20, overstayed, you can still apply, but that is a high threshold. How do you prove that if I go to my country, I will die? Then you have to prove that this is a matter of life and death.
Okay.
So that is private life. So we've moved from family life, we've come to private life. Then we have other ones that do not fall within any of these categories, either family life or private life. In that case, what do? You have to then look at your circumstance, a medical application or exceptional or high discretion application to the Secretary of State for consideration. And we call it human right, or we call it live outside the rules on the basis of your human right. What aspect of human right are you going to make a case for? We've already mentioned that Article 8 of the European Convention on Human Rights, or the Human Rights Act 1998, makes entrenched provision for right to do with family and private life. That's Article 8. So we've covered Article 8 for family, we've covered Article 8 for private life. So what
Okay.
other human rights claim are you going to make? Then that must fall under Article 2 or Article 3 or Article 4 or Article 5. Matters to do with liberty, matters to do with freedom, and things that call for persecution, so that if you are sent away, you may be persecuted, your liberty may be affected, your freedom may be endangered. Then you can be put in on the basis that I'm making an application on the basis of this aspect of my human right, but human right to do with freeing from persecution or protection from persecution or danger. And that is what we call humanitarian protection or human right claim.
Okay.
Somebody will say that, does that mean I can make an application to seek asylum? Asylum is the simple version of humanitarian protection.
Humanitarian protection. Okay.
You must prove that there is imminent danger ahead of you that affects your entrenched right under Article 2, Article 4, 5, or 3. So if you are not able to make your case, then it will be difficult for the caseworker to make a discretionary consideration favorably for you.
Okay.
So when you are making such application, you can see
Mhm.
that the person doesn't meet any of the specific gateway rules, and so they are applying outside the rules.
Okay. Okay.
Right. Now, let me finish off with this, then I will leave you to probe further.
Okay.
So somebody will say that doesn't mean that I can apply for job and become a worker on sponsorship. Let's open the conversation up. Applying under sponsorship, be it student sponsorship or worker sponsorship, you must have something in your hand. Even with students, if you have something in your hand, they will ask you to go to your country and apply for student visa and enter. But if you have something in your hand, you can then apply to remain as a worker by switching the route. But today, what is the key word? Brakuk, what's the key word under this conversation?
We're
Overstay.
looking at overstayers, isn't it?
Overstayer. So if you're an overstayer, it's not a matter of I have something and I want to exchange or switch.
Mm-hmm.
And so we are talking about overstayer, and therefore I don't expect anybody to say that can I apply for sponsorship? You are an overstayer, so you cannot do that inside UK or in
It has to
country.
be outside.
Yes.
Well, Laura, thank you very much. Let's look at it from this point. Now, if you making that application as an overstayer, would it be at the discretion of the caseworker, or this will be a straightforward application if you meet the requirements?
Right. We have entrenched criteria,
Mm-hmm.
protected criteria. I'm not
Mm-hmm.
talking about the 2010 Equality Act protected characteristics, but I'm talking about protected criteria and ones that are open to discretion.
Mm-hmm.
If I say protected criteria, for example, the law says that if you are applying as a parent and your child has qualifying ability in terms of being a qualifying child,
Mm-hmm.
it will be in the best interest of the child for you to remain with the child.
Okay.
Even though there's element of discretion, you can say that this is more favorable to the parent who wants to remain with the child because it's a matter of the right of the child, the well-being of the child, the right of the state, and the favor the parent is seeking. So there are
Mm-hmm.
four parameters here. We have a child, we have the state, and we have the caseworker. Of course, the caseworker is the state, and also the applicant. These are all individual interests. How do we blend these three interests? So if we have a parent, we have the state, and we have a child, whose interest should come first?
Well, depending on where you're looking at it,
Well,
the state will want to have its interest first, isn't it?
yeah, well, I agree, but the state interest cannot come before that of the child.
Well, a child is involved here, yes.
Exactly.
The
Have
child
a parent.
needs the protection of parents, needs the protection of the state.
So we are looking at. So we have to then um, uh, look at the need of the child or the interest of the child, the interest of the parent who wants to apply on the basis of the child, and the state who is saying or which is saying that the parent cannot remain in the UK because they are an overstayer.
Okay.
Then we look at this competing interest and conclude that in deciding whether to give the parent or not to give the parent, let's focus on the child in the picture. Is it for the child goodness or interest to give the parent opportunity to remain with the child? If the answer is yes, case closed.
Okay.
And the answer will be yes under Section 55 of the Borders Act, and also within aspect of the Children Act 1989, Section 1, which looking at the the factors to consider in terms of the welfare assessment when it comes to decisions affecting children.
Well, the
So
child's interest is paramount, as lawyer has said. Yes, lawyer.
paramount, yes. So you can see that it's not a question of caseworker saying that I feel like giving it to you. The question is, should I give it to the parent in the interest of the
In
child?
the interest of the child.
Case close.
Okay. Well, if you just joined us, we're live with lawyer Charles Asma from BWF Solicitors, and the program is The Community and the Law. We come your way every Saturday afternoon between 4 and 6 p.m. GMT. This afternoon, we're looking at the question: can an overstay apply for leave to remain in the UK? Explicitly, lawyer has said yes, but whoever is in that category as an overstayer would have to meet certain criteria. And we've looked at adults, we've looked at children, we've looked at students, and all the other bits that come into the category of overstayers. Can you do that? Well, talk to BWF Solicitors and they will help you with that. Now, keep your comments coming through. You can send your question to our text number 0739920848, or you can send WhatsApp to the same number 0739920848. And if you would want to pose your question directly to a lawyer, you can do that by voice on 0208 493 7345. 0208 493 7345. Yes, I've seen those live comments coming through. Thank you very much, those of you who are doing that. Others who have not done that, please come and let's join our hands together, pose our questions, and whatever it is that you put on could be of benefit to another person. BWF Solicitors are proud sponsors, are at hand to really help us have answers to our questions and our concerns. So come through. Let's see you. Let's hear you. Lawyer Charles Asma is here. But before then, let's say thank you to BWF Solicitors again for helping us to really unravel this. And of course, they are also ready to go through some of the questions and concerns you have. We'll do that right after this. Again, remember, we have our nugget that talks about applying for leave to remain and your continuous stay where you had something by deception. It does not count as lawful, continuous lawful residence. We'll be looking at that. And I give you the scenario for Kofi Azar, who applied initially with a different name. Later on, it was found out, and that leave to remain was kind of revoked, and he was further granted leave to remain because of family ties. He had a British child. Then Kofi is saying that if they say that his initial period doesn't count towards his continuous stay, then he's going to appeal. And I asked you a question: is he going to succeed in the appeal? Yes, because he had lawful residence before he was revoked. No, because his name was different. Or could it be that the previous leave that was obtained by deception was cancelled and was unlawful? He will not succeed in the appeal. Think about all these things. We'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Thank you very much, BWF Solicitors, for your kind support for this program. We're moving in sojourn on. I mentioned earlier on that if you want to join us, you can come through text 07399208468. You can go on WhatsApp on the same number, or you can call 0208 493 7345. Last one, I've got a couple of questions on the platform, and I know when people have further ones, they will bring them on. But on the topic, is there anything further we need to really know? How successful can such an application be?
Right. So it's a case by case.
Mm,
If I say case by case, of course, every application will have requirements. And that's why I mentioned the application must be valid. So validity requirement, application
mhm,
must meet the requirements to make it legible for you, applicant. So eligibility requirement, again, there must be aspect of finance, whether you can afford to fend for yourself, especially if you're applying as a partner. So
mm,
financial requirements. And as of course, there should be relationship requirement, which is sacrosanct or standard. But there are instances where the person may not meet some of these requirements, and depending on the type of application, we say that they should meet the requirement under exceptional circumstance, EX1, within the rules, or Gen 3.1, Gen 3.2, Gen 3.3 within the immigration rules, which says that where there are family relationships involved, it may be harsh and unreasonable to exclude the other family member from the rest of the family members.
Okay, right. So yes, the explanations are there, and the bits and pieces that you need to know are there. So if you have any further questions on this particular one, you can bring them now on, or you can call BWF Solicitors on 0208 493 7340, or the emergency number 077 You can also call Lawyer Charles Asma directly on 07947 636037, 07947 Matthias says, Happy New Year, lawyer. A friend applied for EU family permit in July 2024 and has not got a decision yet. What can he when can he possibly get a decision? And maybe to add, what can he possibly do as well?
Right. It's difficult to say that the person will get a decision at this particular time, so we cannot be definite on when. But we
Mhm.
can suggest that if they feel that it's been too long, they can apply to ask them why it's delayed. That's what we call unreasonable delay. So you can write to them to say that my application has been unreasonably delayed in terms of the decision. And so you haven't communicated the reason for the delay. It's more than 6 months. But we know that they said 6 months is not enough. It has to be 9 months or 12 months. And so if you still think that 6 months is enough, yes, ask them why the delay and if they can expedite it for you.
Okay. Well, Benatete, thank you very much. Yes, the community and the law is always very educative, so you don't have to miss it for anything at all in this world. It's on live every Saturday between 4 and 6 p.m. UK time, and you can watch us live on YouTube at BWF Solicitors at BWTV. You can watch us live on Facebook at BWF Solicitors and at BWTV as well. Obedankra, a friend of mine is overstayed with a visit visa. With his new partner with a child, can I apply for my partner based on my child's visa? I think it's one of the things we touched on, lawyer.
Yes, and if the so it's not the partner. Well, because he said, can I apply on the basis of the child's status? So
Mhm.
if the child is a qualifying child, then the child parent, which is your partner, as you say, can apply to remain in the UK with the child, and of course, yourself, the partner. And so I think your question falls within, or your situation falls within the conversation we've had today. In case you want to reach out to us so that we look at how best to use the law to assist in any way, please do so.
Okay. Yes, so as I mentioned, you can contact lawyer Charles Asma directly on 07947 636037, 07947 or you go through the main BWF solicitors line 0208 493 7340. If you're in Ghana, you can visit the Ghana office on 055 589 595 now. And in emergency situation, 077 127 61884. Lawyer, there's this question here. It's not on the platform. Let me pick it up from our text line. I live in a house for a very elderly person, and this person wants to well, the word used here is dash the house to me. What are the legal implications of this?
Right. You see, this person says this is an elderly person. We don't know the age and we don't
Mhm.
know the state of mind of this elderly person.
Yeah.
Potential risk will be that the transfer could be done under duress, or the
Okay.
transfer could be done um, without the person intending to do that.
Yeah.
So we want to know, on what basis would this elderly person wish to make a transfer of property or asset to this person who is not even a family member.
Okay.
And again, it has to be agreement. So you have to do it after both parties have sought independent advice from a lawyer, and the transfer must take place. Otherwise, the owner of the asset can add it to a will and name this individual as a beneficiary under this will.
Okay. So in this situation, lawyer, if it's genuine and there is mortgage on this particular property, the person who had been bequeathed with the property, should the person continue paying the mortgage in their own name or rather in the name of the person that took the initial mortgage?
I mean, if there's a transfer,
Yes.
I'm not sure whether the transfer is valid in the first place. But if
Okay.
there is a genuine transfer, then transferee now takes the legal liability to deal
Okay.
with the lender in
The
terms
lender.
of, and of
Okay.
course, the lender will expect that as part of the covenants or the restrictions on the property, one of them will be that the new owner, the transferee, will then the details will be registered as the person to pay whatever mortgage there will be, because there would have been mortgage transactions here and there with new lenders and so on and so forth and all that. So that would be a matter for financial advice. And I would say that I'm not a financial advisor, so individuals should take independent financial advice when it comes to mortgage, when it comes to asset transfers, when it comes to lending.
Okay. Lawyer, somebody is asking if they say that you have acquired your stay by deception. If I marry and I'm not able to prove my marriage clearly and very well at an interview, but they go ahead to still give it to me, can they come back to say that I deceived the immigration officer?
Well, they would have then found something new to support the conclusion that the leave was obtained out of deception. And
Mhm.
so, of course, raising a point that the previous leave was obtained out of deception is not conclusive, and therefore the person making the allegation will be required to prove a case, and you would then have the duty to respond to that allegation. If they have proven that, then the what we call the presumption will be that they have made out their case. So you too come in, and then the burden will shift to you to also prove it. So it's not
So,
straightforward.
so in this case, ideally, you would want to appeal against it, isn't it?
If they say on that basis, then of course you want to test it in court.
Well, test it in court, and you can rely on BWF solicitors to help you do that. This afternoon, we have discussed whether an overstayer can apply for leave to remain in the UK. We're taking your questions, your concerns, and we sending over to Lawyer Charles as well to help us do that. Could applying for leave to remain as an overstayer affect my eligibility for future visas or residency applications? Beatrice is asking, lawyer.
No, it depends. But I mean, what we are saying is that you have legitimately obtained leave and you
Mhm.
continue for 10 years. And once you have been legally resident in the UK for 10 years, you can apply for indefinite. But if in future it is found out that the first leave had issues, then of course it will trigger doubt. But again, in future, if you are going to make another application, you have to meet the requirement. So I don't think the conversation about deception comes into being an overstayer. What we are saying that yes, you have breached immigration rule, but when you are making a transition to become to regularize or to be given leave to remain, you follow the rules. And once you have followed the rules and tick the boxes and you've been granted, we have moved from being an overstayer to a legitimate resident or lawful resident.
0739920848. That's for our text and WhatsApp messages. Or you can call us on 0208-493-7345. A resource person and guest from the stables of BWF Solicitors, Lawyer Charles Asma, who's helping us answer your questions and keep them coming through. Yes, what evidence or documentation would I need to provide in my application to demonstrate that I should be granted leave to remain despite me overstaying?
We have defined the parameters for each visa application. Your job is to look at what I need to prove eligibility, to prove finance, and to prove the rest. Then you'll be able to, because we looked at so many aspects of visas, I cannot say that these are the documents because each application will require set of evidence. So if you need specific support in your matter, please reach out to us and we'll be able to work with you.
Working with you is the priority of BWF solicitors so we can find solutions and tailor make those solutions to your situation and get you the resolution that you so require. Remember, earlier on we mentioned that people go to BWF solicitors and they have had positive results. Mercedes Insura came up with something full of praise for BWF solicitors, saying that the situation she was in was quite dire. They refused the application for two of her children, went to Uncle Ben, spoke to him. Uncle Ben handed the case over to Lawyer Charles Asma, who's our resource person this afternoon. And then Lawyer Asma diligently took her through every step of the application. And for 6 months now, her children are with her. So why are you not going to go to BWF solicitors? Please go to them, talk to them, and they will help you. 0208-493-7340. And as I said, if you need to talk to Lawyer Charles Asma himself, you can call him on 07947 636037. 07947 636037. And also remember, BWF solicitors, they help us, empower us, provide us with various updates and pieces of information that will help us understand what the immigration issues are. And every Monday they drop in our nuggets, and then we run through with it throughout the week. And on Saturday, we use that as a scenario for our quiz. And this afternoon, in fact, this week, we looked at continuous residence. And there's a case law that says that leave obtained by deception does not count as continuous lawful residence. That is R versus Secretary of State for Home Department 2024, UK Upper Tribunal case 00417. The court has found that lawful residents must exclude leave obtained by deception and therefore unlawfully. Well, let's see, if we don't have any more of the questions, we will quickly take a break, and when we come back, we'll look at our scenario. Kofi Azar is in the case now. Kofi Azar was granted indefinite leave to remain under the false name, maybe a different one, when he used a different name. The leave was subsequently revoked on the grounds of deception for using that false identity. He was subsequently granted leave to remain on the basis of his family life as he has a British citizen child. He applied for indefinite leave to remain, combining previous leave obtained by deception. That is when they said he used a different name, and his current leave. His application was refused. The Home Office cited the use of a false name and the revocation as reasons he cannot rely on the previous leave. Kofi decides to appeal. Would he succeed? There are three scenarios I've given you. Choose one. Is either yes because he had already had lawful residence before he was revoked? Could it be no because his name was different? Or could it be no because the previous leave was obtained by deception, therefore the leave was unlawful? Think about this. I'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back. And just before we go to look at what answers you would give me for my scenario, let me see if I can go onto the phone line quickly now and pick up a call. The number is 0208 493 7345. 0208 493 7345. Hello.
Hello, good evening.
Good evening. How are you, my friend?
Um, Question, please repeat your question.
Yeah, I was asking how you're doing. How are you?
I'm very well. And you?
Yes, doing very well by grace of God. Now let's hear you. What question do you have for lawyer Charles Asma?
Right. I've sent my question to lawyer Asma, but I want lawyer to elaborate it a bit more. So the
Okay.
first one was, could someone switch from 10 years route to 5 years route as a parent if they are married? Lawyer said yes, provided it's necessary. And I wanted lawyer to elaborate that one more. And the second one was, if someone has been here since 2023 as a student, and
Mhm.
the person couldn't complete their education due to financial situation.
Mhm.
However, the other partner has now been got access to construction CS, and the student now want to switch to be dependent on the household. And would that be possible for the person to switch to be a dependent on the household? Like I said, no, but I just want a bit of elaboration.
Also, you want clarification on both questions. Okay, let's see what a lawyer can give us briefly.
Right. So the first one, I said, if you think the switch is necessary, you may decide on switching. The reason is this. If you are switching to 5 year route, barring even the requirements, you want to know whether you are switching to five so that you can finish the process to be able to apply for indefinite, or you have to start the process all over again. If you switch to 5 year route, you have to start the journey under 5 year route. Imagine if already I didn't even ask how many years have they done already. I'm assuming that they've gone past, for example, half of the journey. If the person has already covered two and a half twice, and they are switching to 5 year route, then they are going to start all over again. By the time they finish the 5 year route, they would have already covered 10 years anyway. So why do you stop to start with a process which is strict? Why don't you stay on the flexible process to the end? And that is why I said whether it's necessary. So whether it's necessary means that how long have you stayed on the 10 year rule? How long? Is it two and a half or two and a halves?
Just a year.
One, so the first two and a half.
Yes.
Okay, so the first two and a half, they got it based on the child, right?
Yes, please.
Right. And they are now married and they want to apply to remain with husband or let's say spouse, right?
Yes. And still
That's
switching
so
to 5 years under the parent route.
5 years parent route. Right, I mean, 5 years
Yes.
parent route, again, there are requirements. There's English language requirement and there is financial requirement. Financial requirement talks about adequate maintenance. Whilst the 5 year route, you didn't have to prove so much. With this one, you have to prove so much. So even though you are not looking at 29,000, you are still looking at adequate maintenance, comparing your situation to somebody on benefit, whether you have enough left to be able to survive you so that you don't go on benefit. These are the things the caseworker will be looking at before deciding whether you meet the 5 year route or not. So the pain of exams, the pain of getting somebody to support or to prove that, yes, you have adequate maintenance, and so on and so forth. That's why I said that it may be necessary to stay where you are. But if putting the two together, you think you are better off on the 5 year route, yes, you can switch, because that will save you time in terms of the journey to settlement.
Okay. Thank you.
The
And what is
second,
the second one?
the second question, right?
Yes.
So the second question, you are looking at switching from student to skilled worker, right?
The person came in as a student, couldn't complete the
So
education.
it's the same thing,
What?
isn't it? That's what I'm asking.
Yes. Yes.
Yeah, switching from student to skilled worker, construction, isn't it?
So here's the case. It's not the student who have got the construction field. It's
No,
the spouse.
okay, so it's the same thing. So this person is on a student visa, whether they completed or they didn't complete, they came as a student, right?
Yes.
Maybe they have. Do they have leave left or it's been exhausted or cancelled?
So within the 60 days.
They have 60 days.
Yeah.
Yeah, so if you're a student, you cannot switch to skilled worker. Now, switching to skilled worker means that you cannot become a main skilled worker applicant. The question is, can you become a dependent of a skilled worker? Because you came as a student, you cannot abandon your student visa to take on another visa within the employment category. And therefore, even though you are a dependent, the law still sees you as benefiting from the skilled worker provisions. And so, it's not easy or um, possible to switch to become a dependent of someone on the construction skilled worker provisions. The person can
All right.
switch,
So
can of course not switching, the person can apply under family life, but not work route.
okay. Okay. Thank you so much, lawyer.
All right, my brother, thank you very much for spending time with us and also bringing your question. And we do believe that your the answer that's been given, so to speak, has satisfied your questions. Thank you very much. God bless you, and we expect to see you same time next week. Now, lawyer, let's quickly see what answers people will bring to the Kofi Azar scenario. Let's see how many will get correct. Kofi Azar was granted indefinite leave to remain under the false name when he used a different name. That leave was subsequently revoked on the grounds of deception for using the false identity. He was subsequently granted leave to remain on the basis of his family life, as he has a British child. He applied for indefinite leave to remain, combining his previous leave obtained by deception with his current one. His application was refused. The Home Office cited the use of a false name and the revocation as reasons he cannot rely on the previous leave. Kofi wants to appeal. If he does, will he succeed? Yes, because he had already had lawful residence before he was revoked. It could be no because his name was different. It could also be no because the previous leave was obtained by deception. Let's see what answers there are before we go to Lawyer. Correct answer says it's number one. Yes, because he had already had lawful residence before he was revoked. Correct, thank you very much. Let's see. Angela says number three. No, because the previous leave was obtained by deception. Therefore, the leave is unlawful. Kwame Fodruo says number three. Same reason as the previous one. Ajani Boateng also thinks it's number three. Adwan Kroma also thinks it's number three. Thank you, Ajua. Next one we have Gifty Poku says number two. No, because his name was different. Well, Ajua says his appeal will not succeed because his name was different. Mami Dufie says number three. No, because the previous leave was obtained by deception. Millicent Osei also thinks it's number three. Previous leave was obtained by deception. Nanaya also thinks same, number three. Okay. Number three seems to be very popular. Daniel Fosu says yes, because he already had lawful residence before he was revoked. So they can't take it away from him. His appeal will succeed. Hanadankwa says no, the appeal will not succeed because his name was different. That's number two. What next? Not next. Okay, now let's see what lawyer will say and let's see which one will be the correct answer. Was it one, two, or three, lawyer?
Right. I think within the nugget, somebody may be that, wow, this one, it may be obvious on the list. Because we are told that there has been a revocation of previous leave on the basis that it was obtained by deception, right?
Mm-hmm.
And he went ahead to combine that one with the new ones to count towards residence for 10 years, right?
Yeah.
And therefore, within the case of R, the Secretary of State 2024, Upper Tribunal says that you cannot mix good and bad to take advantage of totality.
Mm-hmm.
And so the answer will be not possible.
Answer is not possible. I know we're running out of time, but let me quickly pick Ibrahim Munkale's question quickly, if you don't mind. He says, under the 20-year family rule, do I need to make fresh passport from the country of origin before making an application? Anyone is working, does a person need to stop working before making such a submission? He put that on YouTube.
Well, I mean, this is 20 years. 20 years is not family, it's private life. So, fresh passport. Of course, if you are making an application, you have to have valid passport. So, if you have to get a new passport because the previous one is expired, yes, do before you can apply. You have to do from the country of origin. Every country has embassy in the UK, so you have to go to the embassy to get a passport from there. And if one is working, does the person need to stop working before making submission? I mean, well, not working, you know you are not supposed to be working. But the argument is not about working. The argument is that you've been in the UK lawfully for 20 years,
20 years.
including the pay slips, the bank statement, the GP records, hospital record, poll card, letters, whatever you have to prove that, yes, it is you living in the UK for 20 years. And so they're not going to punish you for illegal work, but they are going to credit you for being resident in the UK illegally.
Okay. All right. So, Munkaila, thank you very much. And I know you thought probably we would have missed it. No, we don't miss those things. So thank you for your question, and lawyer, thank you for the answer as well. And as transition demands, we'll have to have the summary of what we discussed before we draw the curtains down.
Right. So, viewers and listeners, today we looked at whether it's possible to apply to remain in the UK having overstayed your initial leave. The answer is yes. We said that there are different categories, and therefore you have to look at a particular category, check to see whether you meet the rules, and put in application. The categories are family route, as a parent, as a child, or as a partner. Each of the three has its own requirement, and so make sure that you meet the requirements there. We also said that you can apply as an overstayer to remain in the UK based on your private life. We said that there are three aspects. One has to do with, actually four, children. Children who are under 18 years, they get indefinite if they have spent 7 years in the UK. Children who are 10 years will get residence or citizenship if they were born in the UK and have lived in the UK continuously for 10 years. Children who are 18 years but under 25 years will have 2.5 years under 10-year route if they are able to prove that they've been in the UK illegal, or after the overstay, they've been in the UK half of their age, including even the time they entered, half of their age. Then adults over 25 years will have to prove that they've been in the UK in the UK continuously for 20 years with leave or without leave, and they can prove it. Or they have been in the UK less than 20 years, but removing them from the UK can affect their life. Then you move on to those who don't meet any of these categories, but they still want to rely on human rights. So we are looking at persecution if you are sent away. And if there is imminent persecution or threat to life, you can rely on that to remain in the UK. We call it humanitarian protection. And there are others who have also not evidence at all within any of the categories, what we call live outside the rules. That is pure discretion. They tell their story, argue their case for the caseworker to consider whether they should be allowed to remain in the UK or not. And because these are to do with overstayers, it is not about switching, because if you're an overstayer, you have nothing to switch. Again, if you are a visitor, you are not an overstayer if your visitor visa has not run out completely. These are the things we have discovered or discussed. And so in any of the applications, you have to make sure that the rules are met so that you can expect a favorable consideration of your application. In case of help, you know where to go.
Yes, in case of help, you know where to go. I would direct you to the fourth floor of the Anna House, 214 to 218, Tottenham High Road, Seven Sisters, North London. BWF Solicitors is where you have to go for your help when it comes to immigration and, of course, all legal issues. Call them Monday to Friday between 9:30 in the morning and 6 p.m. in the evening on 0208 493 7345 0208 493 7345. You can visit their website www.bwfsolicitors.com, or join us when we have our various legal education programs, and especially on the community and the law, every Saturday between 4 and 6 p.m. UK time. Lawyer Charles Asma, thank you. Thank you so very much. You have been so gracious, so methodical, and I've had the tolerance to answer all our questions. And to you viewers out there, I want to say thank you very much. Without you, we wouldn't have a good program. And then I would implore you to invite people to join us again, same time next week on the platform. We're talking about BWF Solicitors Facebook, BWF Solicitors YouTube, BWTV Facebook, BWTV YouTube, and we will give you another edition. And in case you've missed any of the editions we have had in 2024, 2023, or years back, and probably you missed part of today, you don't have to worry. The videos are there on our Facebook and YouTube pages, and you can revisit them anytime at your convenience. But tell people that we'll be live again same time next week. So on behalf of the production crew, Auntie Sandra Fraser, Auntie Cynthia Brown, the all workers of BWF Solicitors, all the lawyers, all the case workers, and especially to Lawyer Charles Asma, Lawyer Eunice, and the principal, Uncle Ben. And to Sandra Fraser and Padmore Dudu, and especially to my studio producer, Professor Ade, we want to say, have a good evening, Happy New Year, and we will meet you again, same time next week. Good evening.